one neighbor in what it was a beautiful part of the province, like gorgeous, pristine lakes and forests, built a 8-foot high plywood fence across the entire boundary, 1,000 yards of property of a plywood fence. It looked like Berlin in like 1962. And so you see people do crazy stuff when it comes to their property and their neighbors. Hello and welcome to Beneath the Law. I'm Gavin Tighe. Stephen Thiele, how are you today?
I'm doing great, Gavin. How are you doing?
I couldn't be better. It's a beautiful summer's day here in central Ontario, Canada. And for our listeners around the world, as I'm fond of saying, for 2 months of the year, the most beautiful place on earth. And, the other 10 months, not so bad. But 2 months, it is pretty special.
I don't know. I'd say 10 months of the year are not bad. 2 months are really bad. January and February.
Ooh, January and February. February is our F word here in Canada. We don't like it. It is chilly. Very, very chilly here in Canada in February. Not a fun place. No. But in July, it is spectacular. So inviting all of our listeners from all over the globe, if they're interested in a great vacation, Canada, July and August, that's your place, I think. Just saying. Anyway, so one of the things we do have in Canada is a wonderful sort of hinterland that surrounds our major metropolitan centers. In Ontario, Toronto's our largest city, but up just north of Toronto and to the east and the west north of Toronto is probably one of the greatest playgrounds on earth, with the thousands, hundreds of thousands of lakes and rivers and streams and forests and cottages. People vacation up here in central and northern Ontario in the summer months, particularly. And cottages are a place of refuge, peace, and tranquility most of the time.
Yeah, most of the time. And we've seen a lot of cases where these cottage properties end up pitting one neighbor against another for very silly things. And one of them being, I need access to my cottage and it's landlocked and I need to travel over somebody else's land to get to my peaceful and tranquil place.
Yeah, I mean, one of the things about the beauty of the geography of northern Ontario is it's kind of all over the place. You got these crazy odd shaped lakes and trucks and huge rock structures and whatnot. So you often have land that is not configured very, geometrically and in odd ways. And sometimes you can't get to certain properties. You got to cross over your neighbor's properties. The other thing too is that a lot of these cottage properties were created, in the last 100 years or so. It was pretty ad hoc. I mean, people would, go up and stick their cabin up here or there or whatever. And, okay, no problem. I walk across my neighbor's lawn. No, that's fine. And you have a lot of kind of loosey-goosey, if I can use that word, structures in terms of property holdings, particularly in cottage country. And one of them, it was involving a kind of strange, I thought it was a little strange, setup with a co-op, and they had like a group of properties, and then they had kind of communal, which is not uncommon. Like you'll often see that in cottage properties, and they'll all get together and, I don't know, they build themselves a tennis court for all the neighbors. And the tennis court is operated sort of cooperatively, and everybody kicks in some money to maintain it or whatever. But that's all very nice in generation number 1 when everybody's getting along. But by generation 5, and the properties have switched hands 6 times, sometimes people don't get along so good.
Yeah, no, for sure. And I think, Gavin, to your point, a lot of these cottage communes, were developed 60, 70, 100 years ago without real infrastructure from the municipality, right? So you have...
Well, there is no infrastructure.
One roadway, right.
Private roads, and everyone's on a well. Everybody's got a septic bed, and nobody's got municipal water or anything like that. And the other thing too, I think it's important to remember, look, one thing Ontario and Canada has a ton of was space. I mean, 100 years ago, you could buy a lakefront cottage property, 200 acres for probably about $10 because there was just so much of it. It was like, well, of course, it's never ending. And now, those same properties are going for millions of dollars. So the value of property has increased exponentially over the course of, the last 100 years, such that now what was sort of, oh, well, no problem. There's tons of property. If I don't like you, I'll just move to the lake next door. No big deal. Now it's become quite valuable. And when, land, people get very, very fussy about land. And I'm often say that one of the things is I think more wars have been fought about land pretty much than anything else.
It certainly fills the real estate legal books. And, there was a case here in Ontario, as you say, involving a not-for-profit corporation selling 19 lots of land back in 1960, with each, they called it a share, being attributed to a specific lot. So we had these lots that were bought and sold at that time, or shares in the not-for-profit corporation. And one of these cottage lots was landlocked, right? It was only accessible by water. And so in real estate law, generally where you have a landlocked property, you generally create agreements, which are called rights of way or a right of way, to permit the landlocked property to have access to the major roadway that is nearby. And so that's what happened in this particular case. But as you said, Gavin, 5 generations later, when somebody else is purchasing the property, people look at the right-of-way and say, well, hang on a second. You're traveling over my land. You're not supposed to be traveling over my land. And then erects a fence to block that person from traveling over their land.
Right.
And
so just in terms of, like backing this up a bit, just so that everyone, there are what are called easements, and easements are right of ways or whatever. An easement is the right to cross over someone else's property. And so like, there's tons of easements around all over the place that we see all the time. So for example, hydro lines go over property all over the place to carry power. And hydro lines will, generally speaking, be subject to an easement. They have a right to run their hydro lines over someone's property. So similarly, there are easements all over the place, literally, and there are different types of easements. Some of them are agreed to. Now, one of the things that is interesting, and I think is not the case here, is there is something called an easement of necessity. And an easement of necessity would be for a truly landlocked parcel that otherwise would be useless. In other words, you couldn't get to it. The law will sometimes presume an easement over a property,
a neighbor's
to get
land,
to it.
Right.
There are other easements, which are called easements by prescription. So one of the things, concepts I think is important to remember, and this is an interesting one in Ontario now, and I don't want to get too into the weeds on it, but anyways, there is a Land Titles Act in Ontario, which arguably takes away the easements of prescription, but in this particular instance, not necessarily. So if you use a property for a given amount of time, and I think it's 20 years is required for an easement by prescription. If I've been crossing over your property for 20 years and you have not objected to it, I can argue that I've now got a right to cross over your property. The weird part about it is if you said to me, oh yeah, Gav, no problem. You cross over anytime you want, buddy. You have my permission to do so. And what a great neighbor you are, Stephen. That actually is bad for me because one of the things I require in order to get the right to cross over, not the permission, the right, is it has to be adverse to your interest. So if you let me do it, it's not adverse. So that really was the big issue here. There had been this driveway. They've been crossing over the driveway to get to their property, I guess for quite a long period of time. And they said, whoa, wait a minute. If we have a prescriptive easement by this point. And then they said, no. I've been letting you do it until now, because now I don't want you to do it anymore. And I've changed my mind. And now I'm saying I'm building a fence. So that was really the argument, was, I thought, when I looked at the case, was the use permissive or not permissive? And I think the finding was it had been permissive.
Correct.
And one of the things about permission is it can be taken away.
Yeah, so just to fill in some of the facts here, essentially we have this landlocked lot, right? It doesn't have access to the nearby roadway in order to drive a car to this lot. The co-op or the corporation that was selling these lots had developed an agreement. There was a resolution that was actually adopted by the quote shareholders of this community, giving a road access or right of way so that somebody could reach this landlocked lot by car. And basically, there were two adjacent properties over which this right of way appeared to have been granted. But what nobody knew was, where was the access point from the road to this landlocked lot. And so the person who had the driveway basically said, no, you've been crossing by permission. The access was on the adjacent lot. And indeed, there had been, I guess, a pattern of use at some period of time. And we're talking like it was 12 feet wide on the adjacent lot. I think one of the things, and again, this is why this is beneath the law, what influenced the judge and the landowner who had the driveway is that the landlocked owner was actually using the driveway for other purposes.
Yeah.
Right? Like they were storing things.
They were a bad neighbor.
They were bad neighbors, right? They were storing things on the person's lot, and the person was getting upset and had enough and said, if you're going to be that kind of a neighbor, sorry, you can't use my driveway anymore. Use your other access point. It might be a little bit more inconvenient for you, but really that's where the access point is. And the judge agreed with that. Yeah, and I think that influenced the judge, to be quite honest.
Oh, 100%. And I've had a number of these cases over the years with landowners, etc., neighbors. And it's funny, people like talk about acrimony. There are very, very few disputes more acrimonious than neighbor disputes. I mean, you even think of a family law, it's one of the most acrimonious areas ever, but at least those people liked each other at one point in time. I mean, neighbors, you don't really, you don't get to pick your relatives or your neighbors for the most part. So, you can get a neighbor that you really, really don't get along with, or that is a really obnoxious type, or covetous, if I can use that word, of property, and you'll see this all the time where people try to creep their fence over, or they try to do something. People get really irritated about that. Like that is a major piece of agitation. I've had cases where up in cottage country where there was a dispute over a boundary dispute, and one neighbor in what it was a beautiful part of the province, like gorgeous, pristine lakes and forests, built a 8-foot high plywood fence across the entire boundary. I mean, we're talking like 1,000 feet or 1,000 yards of property of a plywood fence. It looked like Berlin in like 1962. And I've absent the machine gun turrets, although I suppose he might have put a few of those up if he could have. That would be another episode. But so you see people do crazy stuff to really, when it comes to their property and their neighbors.
Yeah, and you mentioned that. I recall you having a case many years ago in Toronto, right, where you had basically a mutual driveway. In order for a person to be able to drive their car to the back of their property, because that's where the garage was, and the other neighbor put up a fence down the middle that basically now prevented that car from actually accessing the back of the property.
No, they took a concrete saw out and sawed up the property line on the driveway. Now, in fairness, The other neighbor had decided to also invest in, at the time, closed circuit television cameras that just so happened to be pointed into every window in the neighbor's house. It was
I see.
beyond creepy. So you had, yeah, listen, generally speaking, there are no saints in the neighbor fight. There are just degrees of sinners. But the reality is these neighbor squabbles can get very, very, very heated. And this one clearly did. I mean, and you kind of get it. One neighbor gets ticked off, and buddy is storing all his junk on their property.
Yeah.
And I'm sure and I didn't know the facts of the case well enough, but I'm sure had been asked nicely can you please move your junk? No, I don't want to move my junk. And then the next thing is, well, okay, you don't want to move your junk? No problem, buddy. I'll put a big fence right across your driveway, and you won't be using anything. And then it ends up in a courtroom with a judge deciding if there was a right to put the fence up or no right to put the fence up. And in this particular instance, the frankly self-help remedy of the one owner of putting the fence up, because I would strongly caution a client against doing that, because I think judges get a little annoyed when people run to court after imposing self-help remedies. I mean, the cutting of the driveway with the saw was not a good move. I would have preferred to be there saying, we'd like to be able to do this, Your Honor, if that's okay. Sometimes it is better to ask for permission than forgiveness. So that I didn't seem to turn the judge off. The judge seems to, frankly, have been more turned off by the bad behavior of the junk storage war neighbor who decided to put all their crap on their neighbor's property.
Yeah, look, I agree with you. Self-help remedies, Gavin, are not necessarily the way to deal with any dispute. But as you know, people spend a lot of money in court over these kinds of disputes.
Ooh, wow.
Right? Whether it's a right-of-way dispute or an adverse possession dispute, they're spending hundreds of thousands of dollars.
Absolutely.
And one of the things that I think also influenced this particular decision is the landlocked neighbor or the landlocked owner claiming that they had a right of way over this driveway did not go back to get evidence from previous owners to indicate that they had the right of way. And that was, I think, a major failing.
And it's really hard. I mean, one of the things you say, well, how hard can it be? I mean, I had a case, several years ago involving a cottage property and a claim that there was a right of way over the neighboring property to access the water. And they tried to go back. They had to go back a long time. So try to get evidence of what the use of a property in like rural Ontario was in the 1960s or the 1950s. Good luck finding someone who A, was alive, and B, if they were, can remember. And it's got to be continuous. So the issue is, do people continuously cross this property for a period of 20 years in the 1950s and 60s?
Yeah, for sure.
That sounds, try to prove that. No, they didn't. Prove it. And so find a witness. Good luck. I mean, people are off to have blown off to the four breeze, and people in the 1950s, those people are now in their 80s or 70s or 80s, even if they were children. They're no spring chickens at this point in time. So getting that evidence, and certainly getting any documentary evidence or photographic evidence, is challenging. But if you're going to make that claim, you better have it.
Right. But in terms of photographic evidence going back, I know that we've spent time on cases where you can now do, Google searches and go back in time to see and locate and take a screenshot of whether a car was parked on a certain road or not.
Street View will do it. You can go
right
now you can now, but I'm saying there was no Street View on Google in the 1950s. But you can get. We have, in fact, in other cases, gone through municipal archives and got aerial photographs
exactly
from decades gone by. It's very helpful, but it's got to be used to support actual evidence of the use of that particular property.
Yeah, and so anyway, one of the other things that strikes me about this case, because we're now seeing it more and more in terms of legal trends, neighbor disputes are actually being determined by mediators now, and there are a number of organizations that uh, uh, permit neighbor disputes to be, uh, you know, determined or resolved by a mediator, which reduces costs. There are social organizations that permit people to volunteer as mediators. Anyway, so there are organizations now that permit mediation of neighbor disputes, and
Yeah.
I'm just wondering whether this kind of dispute could have been more easily resolved, or a better resolution could have been obtained by going to a mediator rather than going to court, where there are winners and losers. Right? Mediators are generally trying to get the parties together for a win-win situation, and here, like I said, I think in this case, the judge was influenced by the landlocked owner's misuse, I guess, of the quote right of way or the driveway by, storing various things. I don't know if it was junk or just other things,
Yeah,
boats.
we're
I don't know.
assuming it was something noxious, but I mean, yeah, I'm with you. I think, frankly, though, by the time that the parties have gotten to the stage of suing each other, the neighbors, it's pretty ugly, and people are pretty dug in on their positions. And frankly, a lot of this is, in my experience, really, really nice people can become quite unreasonable when it comes to their property. They get very. It's one of these. I think it's built into people. I think it's people are hardwired to be very protective of their of their property. I mean, their turf, and we as a species get a little antsy and unreasonable when it comes to people that we think are infringing on it. I mean, I'm always reminded of the Robert Frost line that good fences make good neighbors, which
Yeah.
is absolutely true. Yeah, because when you get into arguments about where the fence should be, boy, people really go off the deep end.
No, look, although Canada doesn't have a right to property in its constitution, we fight over our properties as much as the Americans do.
Probably,
And
yeah. I mean, we've certainly seen I've certainly seen my fair share of it over the years. I mean, it's become a little less um, uh, litigious since the advent of the land title system here in Ontario. I mean, it used to be a registry system here in Ontario, and it made those types of claims for adverse possession, prescriptive easement, I think, a lot easier. That you see a lot more of them. Under the land title system that we now have in Ontario, it really doesn't matter if you've got prescriptive use of a property, if you're trespassing on your neighbor's property, at least from a legal perspective, because the title to the property is whatever the title to that particular abstract says it is. So if your title says you have 30 feet of frontage, you've got 30 feet of frontage, and it doesn't really matter if your neighbor sticks his fence over an extra 6 inches. You've got 30 feet. You own the 30 feet. That's what the Land Titles Act says. That's what you own. Period. So there's no, to my view, prescription doesn't really matter that much anymore under the land title system.
well, it doesn't. But as you know, there is the doctrine of lost modern grant
Mm-hmm.
that would permit a person to still make that claim prior to the first date of it going into land titles, if they could
Right.
go back. Right,
Yeah,
but that's
that's
the
the point.
evidentiary issue, right?
Yeah, so it's got to be 20 years
Right, or 10 years,
before
right?
it got converted, and everything got converted in the early 2000s. So I don't think there are any registry properties left in Ontario. I think they've all been converted into what's called land titles qualified, which means that, that was the date that the clock stopped. So you got to go back 20 years before that. And as I pointed out, that's getting harder and harder. Try finding, somebody who can remember, who walked across little Susie's path back in 1982.
Yeah,
Um, those people are becoming fewer and fewer and harder to find as days go by.
yeah, for sure. Anyway, that's why we dig into cases like this. This is an interesting case. These are the issues that when you get beneath the law come out, and that we like to discuss.
Absolutely. So thanks very much for listening as always. Stephen, thanks again for your comments. Doug Downs, our producer. Please send us comments, questions, criticisms. Kudos are always welcome. Rare, but we love them. And always remember, if no one is above the law, then everyone is beneath it.